Now we confront the hardest material in this chapter, the gap between the ideal of equal justice under law and the documented reality, particularly in the criminal justice system. The textbook does not soften this, and neither will I. The blunt claim is this. From its beginnings, the United States has maintained what functions as separate criminal justice systems for black and white Americans. The history runs from the explicit racial terror of lynch law in the South, illustrated by the 1955 murder of 14-year-old Emmett Till, whose killers were acquitted by an all-white jury in less than an hour, to the more subtle but systematic disparities documented by social scientists today. The evidence shows that black Americans are stopped, searched, arrested, charged, convicted, and sentenced to longer terms than white Americans committing comparable offenses at every stage of the process. And recall from our civil rights chapter how hard these disparities are to challenge in court. In McCleskey v. Kemp, the court held that statistical evidence of racial disparity in capital sentencing was insufficient to prove intentional discrimination in any particular case. So the systemic pattern is real and documented, yet it falls largely outside the reach of constitutional doctrine, which demands proof of intent. A central problem is racial profiling, treating race or ethnicity as an indicator of criminal propensity and using it as a basis for stops, searches, and surveillance. It's both a civil rights violation and a practical problem for law enforcement legitimacy, because communities that feel targeted lose trust in the system. The murder of George Floyd and the national reckoning that followed brought renewed attention to these disparities, producing reform efforts in some places and backlash politics in others. One legal doctrine you should know here is qualified immunity, a judicially created doctrine that shields police officers from civil liability unless they violated clearly established constitutional rights. Critics argue the standard is so demanding that it effectively insulates officers from accountability even for serious misconduct. As of 2026, the debate over police accountability, qualified immunity, and the structural sources of racial disparity continues without resolution. And the inequality isn't only criminal. Equal access to the civil justice system, the ability of people of limited means to obtain representation and actually use the courts to vindicate their rights, is an equally persistent problem, with legal aid infrastructure chronically underfunded relative to need. So when we say equal justice under law, this section forces us to ask, with intellectual honesty, how fully that promise has actually been kept.